voted on, and I think that was the motion you voted for. So that's the open session for you just put in, you made the motion, who seconded it?
We will now open the Rules and Regulations Committee for the Mississippi Board of Medical Licensure on May 20th, 21. We had several things we're going to discuss. Thanks to the Supreme Court, we cut out part of it, a third of it. So let's just dive into the front. We had written rules on the practice of telemedicine, part 2635. And I think we made some minimal changes here, mainly in definitions and syntax. One thing, well, one thing we want to talk about was this part 2615, when we talked about practice of telemedicine. We were having doctors and PAs in the same office in San Diego practicing medicine in Mississippi that never been here and didn't intend to come here and didn't have an office. And our regulations on NPs was that the physician had to practice in the state 20 hours a week, if I'm not mistaken. But this was getting a little out of reach when they're both in San Diego. The licensure board really has no hook in San Diego. It'd be too expensive to send Jonathan to San Diego to investigate something.
What page is it on?
That is on page, I don't know, it's behind Rules, Regulations, Legislation, the first page. It's kind of a summary page.
Dr. Miles, if I may.
You should
add
go
on
ahead.
to that. So Dr. Cleveland can speak to this too, which he's not here right now, but we had a very good conversation with some of the staff members that are affiliated with OLRC, kind of a pre-meeting on 2615. And these are all rules that the board's previously passed, and we're just waiting on the OLRC on 2615 and 2630 anyway. And there were some thoughts about what the board had proposed and what the OLRC is probably going to be comfortable with. So there were some suggestions kind of in advance of that meeting on what we might could tinker with to make it more palatable, and we felt like those were good changes. So these particular three, the 2 in 2615 and the 1 in 2630, represent some of those, or all of the changes that were substantive to some degree. But these are changes that they thought would be more palatable to the governor, Secretary of State, and the Attorney General when the actual meeting takes place. So these are kind of a heads up for the board that these are the changes that they're foreseeing we need to make this passable by the OLRC, which they seem very reasonable to us.
Well, what I saw seemed to be just cleaning up maybe redundant language or making things just flow better from a semantics. And so I guess was there any real substantial policy changes that we made with this?
There were. So in the sense that, so previously the board had passed rules specific to 2615 and 2630 about the primary care extended mileage language, which one of the requirements of that, and that's an option for situations where they're outside of the 75 miles. One of the options was this primary care extended mileage. And within that, you have certain requirements you have to meet. And one of those is you have to work at least 20 hours a week or 80 hours a month in the state. What the board's doing here with this is making that a global requirement for all collaborators, whether that's with nurse pracs or PAs. So in order to be a collaborator, you must work at least a minimum physically within the state, excluding telemedicine. So we have some level of long arm, as Dr. Miles was alluding to. It's hard to put investigators on a plane to California and serve subpoenas.
You said excluding telemedicine. Do you mean
Yeah, excluding. We do not include telemedicine as part of that. So if you're sitting in California, you never physically come here for those 20 hours, telemedicine doesn't count. You have to physically be here to be a collaborator, at least 20 hours a week. That's what's been passed by the board already. That's at OLRC level. So the question with that is can there be some exceptions potentially? We've already had one group out of New Orleans who is a psychiatric group that does some coverage with psychiatric nurse practitioners in the Delta and other parts of the state express concerns. So the suggestion that OLRC came up with, and one that we had been kind of thinking about in the interim, was an exception clause to that, because there are going to be some times that you want to accept people that are on the fringes that may not physically work but are just over the border, and situations that you find all right. So that's a suggestion they made. It's been put in here in the form that it would be if you were to approve it when the time comes. But again, I don't know that there's anything you need to vote on for that. It's more of a heads up of this is probably what the OLRC is going to find palatable.
We have this written in here on a page. I couldn't find it.
Yeah, my book is kind of out of order.
My page is on number.
It's in the back.
Yeah. So if you look at part 2615.
Where is the exception phrase? I'm not finding that.
2630.
Well, there's 2615 and 2630 both have exception phrases. It should be under Rule 1.2 definitions. What I did was the language that's already at OLRC, I took the underline away so you can focus on what their suggestion is. What's underlined is the suggestion by the staff attorneys with OLRC. And that language is basically the same between the two rules. The sections, well, I could read that if you'd like me to just read it aloud.
So we can grant temporary exception or
permanent.
Permanent.
Right.
Exception.
With the way this is written, the executive director could look at a particular situation and maybe grant a temporary exception until the executive committee could take a look at the request and then make a final ruling at that point.
But if the doctor and the nurse practitioner are both in California, we're probably not going to be an exception.
Probably not, unless they're providing some sort of service that you just find amazing. But that's up to the board on a case-by-case basis. This gives you that levity to do that.
What the rule is that the doctor has to practice in Mississippi for 20 hours
Or 80 hours a month, however you want to met that out.
In other words, they can't accomplish 20 hours via telemedicine.
That's right. Yeah, they have to physically come here. So, and some of the discussion we have with that is, that levels the playing field to some degree. Like Dr. Lippincott, if you were working with a nurse practitioner, any investigator from the board could pop in and inspect your documentation. And we can't do that to somebody from Illinois or Pennsylvania or something like that. So that's not really fair to you as a licensee who's here all the time. And quite frankly, when you send a letter to somebody and give them an opportunity to fabricate stuff, it happens. So if we send, that's what we'd have to do, is send letters to people in other states saying, produce this and giving them periods of time. Whereas I'd show up at your office and you'd have to produce it right then and there. So,
and we have had this for some time in places like Memphis and Little Rock, but this is the first time we've had people both living in San Diego practicing here.
right.
So to kind of change topic a little bit, looks like we've also included language about medical marijuana.
Yes, sir. That's the part that, I'm sorry, I'm speaking off the cuff, Dr. Miles. I'm sorry.
Okay, that's not it. We probably ought to delay the part on medical marijuana till we see what's coming and kind of know the guidelines of what our guidelines ought to be.
Yeah.
Might be preemptive right now.
It might be preemptive to say anything about medical marijuana, because it may not be medical marijuana like that. It might be recreational.
I wanted to bring up something on this. I don't disagree with the intent of the regulation, but I just want to point out something to the board. Like, if we're going to put an exception clause in there, we need to be starting to think about criteria that we're going to use to judge. I mean, the whole reason the OLRC is concerned about this is, in a way, it's the restriction of interstate trade. So if you're going to be using your judgment, then that's going to open the board up to liability on your judgment. So we need, if we're going to put this in here, we don't necessarily have to have it in writing, but we need to have criteria in mind that we can use and justify when we deny somebody this exception clause. So just thinking of that going forward.
Well, it's gonna be whether enforcement is feasible, it sounds like.
That could be one of the criteria.
Basically close proximity, New Orleans, Memphis, Mobile.
Border state, or something along those lines. That's
I mean,
something that
yeah.
the board.
You know, I mean, you could even, if they're willing to pay, if there's something that comes up, are they willing to pay the travel? Just, I mean, it could be a lot of
Yeah.
different things, but anyway, just to. keep
That
in
would be
mind.
good. If there's a problem, are you willing to pay travel for the investigator to go to
Right.
San Francisco for a week?
Well, part of the problem with that though is that if we, let's say they agree to do that, we show up in San Francisco and they start arguing with us about what they're gonna produce to us. If I draft a subpoena, it's worthless in California.
That's true.
We have no authority in the state that they're in, period. Now, the board could take action based on that refusal because we do have a license here. But if they want to pay the bill to refuse, I know that's probably an exception, but in any case, just something to think about.
Well, might I suggest then that we look and see what some sister states are doing about this? I mean, we can't be the only ones looking at this. What does Alabama do about somebody in Maine who do it? Or-
My experience has been that most states have a paper process for stuff like this. It's just because the manpower is just not there. I mean, we're fortunate that we have enough manpower and can go do these inspections and go see people when the time, when we need to. In other states, there's so much of this is paper. And it's always been our policy that we like to go and see in the environment. It's just been the way this board's operated since I've been here and long before I started here. So we can certainly look at the other states and see what their processes look like.
Yeah, I think so. That would be a better explanation for ORC to say, well, this state, these 5 states are doing the same. Rather than us having a unique approach. We don't want a unique approach.
True. Regardless, even if other states are doing it, I mean, if you're setting up a process that in any way restricts interstate trade, you just have to make sure that we have a solid ground for it. I mean, I think we do. I mean, I think the rationale behind it is legitimate.
We've got no problem if the doctor wants to come to Mississippi 20 hours a week by private jet and work. That's great. But so few of them do.
And this is just specific to collaboration, so keep that in
Yeah.
mind. That same doctor can be in California and practice here all the live long day on a license. It's the collaboration component.
When he collaborates with somebody else.
So he can practice telemedicine from California
Sure.
full time.
Absolutely. Absolutely. When you get into the collaboration, it starts to get a little unwieldy, and there's a lot more moving parts involved than just an individual practicing medicine.
I don't want it to seem like we're restricting telemedicine, and that's not what we're doing here. We're restricting collaborative telemedicine. That's,
We're putting some safeguards up
yeah,
to make sure that we retain regulatory authority over those situations when patients are being treated here by those modalities. And I will say that OLRC staff, as we went through this, they just wanted to hear kind of the rationale when they heard it. They said, it makes total sense, but let's put in, and we suggested along with them that the exception would be a good idea because there are going to be times you
Yeah,
want to.
and I think the
accept
exception's good. Like I said, my only concern is just making sure we have some criteria that if there's a liability issue that comes up, we deny somebody, we can say, well, they didn't meet this, this, and this, and this is what we look for.
yeah, we don't want to look capricious and arbitrary.
Exactly.
Indeed. Indeed.
Right.
Legal term, yeah.
Well, have we had problems with physicians practicing telemedicine from distant states?
We've seen a little bit, but what I've seen from my perch is the collaboration thing's becoming more and more common, where you've got groups thousands of miles away that technically fall within the scope of our regulations as far as not needing approval or anything like that. The idea of the dermatologist who's in Los Angeles and has 10 PAs in his office with him, and they're doing teledermatology into Mississippi. That's just a tough situation for us to try and monitor and have real oversight over.
And so why does the California doctor have less regulation around them versus the Mississippi-based doctor?
So that's kind of the vector there.
Does the Teladoc Texas case have any involvement with the situation?
I would say no, man.
No, I wouldn't think so. Because they weren't talking about collaborating, they were
Right.
talking about
Actual work, which we're not infringing on that at all in any way.
Of course, if the California physician is licensed in Mississippi, you've got jurisdiction over it.
Right.
And so you still can be investigated. Now,
Yeah.
there's practical difficulties investigating somebody in California.
Right. That's
But as far as a long arm, if you have jurisdiction, absolutely.
so the thought process behind the hours in the state is that if they're physically here, we have somewhere we can go in Mississippi to find them and lay eyes on them and then get these documents.
The other problem is if he's collaborating with a nurse practitioner in California, we have no way to deal with her. He's triple. So we're gonna look and see what the other states do, and then we're gonna try to put some. Do we have to put reasons for exceptions in there, or just have some available?
I think what Hope's talking about is having some internal policy about how
Okay.
you see
Yeah,
these
just something in
situations.
writing, like
The
something that-
criteria.
Criteria,
Yeah,
just
criteria.
criteria that you use.
Would they need to be in writing?
I don't know that they would have to be in the regulation, but I think if it were just something internal, like the board policy memo, like this is our criteria, just something you can produce.
You develop criteria that mean things that you utilize.
Apply them.
Yeah,
You
apply them.
apply consistently.
We have a policy section. It's something that, we could
And
draft.
you could put it in policy. I think it would be easier than put it in the regulations, because then you can tweak it as you go along. But just something that's in writing that you produce, that if somebody were to challenge your decision, you could say, this is the criteria we used and defend it.
Would you like for us internally just to put some bullet points together to think about, or?
I think so, but you have to understand, as soon as you put those bullet points in writing, some Einstein out there is gonna figure out a way around it. He's gonna have one of these lawyer people find a way around it.
But also, you establish criteria by way of policy. Policies do not have the legal impact of a rule or regulation because you haven't gone through the notice and approval process through the OLRC. But I don't have a problem with establishing criteria via policy, because you're basically just explaining how you're going to enforce the reg.
Okay. Would you and Hope get together with ONRC and see if we can establish some advisory criteria where the board would be able to grant exemptions or not, on some pretty good reasons. And then get back with us and we'll.
We were talking about our pre-meeting meeting with ORC, just kind of filling them in. Hope suggested that we would have some internal policy about when we are thinking about exceptions, what the criteria would be for us to potentially give an exception.
Somewhere down the road, somebody's not gonna like the decision, and they might
Yeah.
get a lawyer
Yeah, we
involved.
started
Just, you
rules
have to
and
have
regs.
something to show.
Oh, yeah.
You didn't just
I
say,
didn't think
"Hey,
it
I
started
like
until
that."
9. My apologies.
8:30.
No, that was nomination committee.
Rules and regulations, May 20th, 8:30.
Oh, my gosh.
And we just went over the part 2615, chapter 1 of the telemedicine, which was the physician assistants and nurse practitioners, both living in San Diego. And that's also the same thing in 2615, on the factor of practice of physician assistant, as well as the supervising physician, and as well as a nurse practitioner. Does everybody see what we're trying to get accomplished here and try to head off conflicts down the road? We can't do it, but we can try.
Are any other states requiring physical presence for a certain number of hours?
We're gonna look into that.
I can
See
see
what
some
our
litigation
sisters
coming out of that, yeah.
Alabama, Tennessee, Louisiana, Arkansas. Any other questions about the rules and regs we discussed? Really, we didn't change anything. We just identified some things that could be problems and let them out to solve when they come up.
And the medical marijuana language to be extracted.
Yeah, I think that makes sense, just to wait on that until we know what the legislative guidelines are so we can stay within them. If it's not gonna be medical marijuana, it may not be, then we don't have any sense.
I mean, I would recommend just table on 26 what we changes.
It's probably gonna come back as a legislative bill and not a constitutional amendment, which is gonna be better.
The rumor right now is that there might be a special session. They might first address the actual constitution where the initiative process is laid out before they do anything. And then they haven't decided yet if they're going to try to address medical marijuana in a special session or wait until January.
Who's kind of real right there? The guy from Madison, is he still?
Joel Bumgar,
Bumgar.
there are numerous parties involved at this point. He was one of the big leaders initially, but I wouldn't say he's like the person now. There's just a lot of different groups.
Is there any talk of having it recreational and removing the word medical? And it's
Not at
one.
not at the leadership level. There are discussions about that, but I wouldn't say it's all the way up to the leadership level.
Can we introduce it at the leadership level?
Yeah. Since there's
I
no-
certainly, I mean,
Since there's absolutely no FDA indication for giving somebody marijuana, I wonder why it's got medical.
I do think it would be good for me to meet with some of the leadership people and discuss that with them, if we can arrange that.
Because if you come to me 2 years from now, and ask me why I gave somebody a note that says she's having marijuana, I'm stuck for an answer.
well, the note
Why
doesn't
did I-
say that you think they should take marijuana. The note just confirms that you diagnosed them with a condition that meets the criteria.
Which would be what?
Like, I diagnosed you with cancer. Did I diagnose you with cancer? Yes. So that's what the medical doctor
Yeah,
does.
we haven't used marijuana for cancer treatment. How long? Right, we have.
But again, you're not prescribing, you're not even necessarily recommending. You're
Well,
just verifying that you
Either.
diagnosed a condition that meets the criteria, or at least that's how the initiative 65 was set up.
And maybe we get Ken to go talk to him.
Yeah, it may be a good idea for you and I to sit down and get on the same page first, and then you help set up that meeting. Because I think as a board, what I'm hearing is we have a little bit different idea about the certification process than what you're describing right now.
I'm just saying what was in the initiative 65. Yeah.
I understand,
Yeah.
but
If they do,
I mean, we're charged with regulating what physicians do and protecting the safety of the public. From that standpoint, I think the board has some different views. I just would like to, for you and I to get on the same page about this.
If you do something, you may want to have them put in the legislation approved for FDA approval.
Yeah, doesn't stop us right there. As far as if you talk government call,
I thought Schedule 1 drugs were illegal.
At the
The
federal level.
DOJ has issued some kind of statement saying that they don't enforce marijuana I mean, basically at the state level.
But it's still the law.
It is
Yeah.
still, I mean, there's a lot of, that was one of the complications. I mean, you can't have a firearm and have a Schedule 1 drug. So, you know, there are going to be a lot of legal complications with having legalized marijuana at the state level that still impacts other areas.
I mean, we're putting in, we can prescribe level 1 drugs if they're illegal.
Again, that's the
What,
initiative
we're
session.
not, first of all,
prescribing.
we're tabling 2640 changes right now.
Right.
But we were saying, if you're going to allow for them, then you have to follow these rules. We're not making it legal by what we put in our regulations by anything.
Anyway, it's moot for the moment.
It's
It
big
is.
for the moment.
and we'll have some talks with the legislators who are doing this and see if we can get with them before they bring it up again. Middle of next week. I don't know when they're gonna bring it up.
Do we need to talk about this 2635 release of medical records? Why is that new?
It's not.
Okay, so it's not new, but the new thing that we're running into when we get to a doctor's office and request records, where we used to didn't have any issues. Now they say, well, show me where it says that in the law, or show me where it says that in your regulations. And so we're just putting something in black and white that we can go, this is where it says it, right here. And we quote the laws. We reference the laws that's based on, so, you know, that the physician that we're investigating understands we have a right to their medical records.
Well, it's always said you have to keep medical records of the exam, the drug you wrote, why you wrote it, and your kind of
This,
treatment plan. They have to show us that.
but they want to argue with us about that now. And their lawyers are telling them to argue with us about that now. And so it's gotten to be a much more complicated process than it used to be, because it used to be that physicians understood that the medical board had a right to send an investigator into their office and look at their offices, look at their records. But now they're meeting us at the front door going, my attorney says not to let you in.
What happens, I get involved, I have to call and educate that attorney as to the HIPAA exception. The statutes which permit it. So if it's in the rules and regulations, it's a little bit easier to
Could
digest.
the investigator say, well, sure, we don't have to see these now, just give me a medical license and I'll be back later.
That would make it
I'll
a lot
come back next week, so you can't practice till I get back.
The answer is definitely we can do that, but then we're going to get a flood of complaints to the governor's office and to the attorney general's office and to the board president about how strong-handed our investigators are being when they come in and all that.
But how are we supposed to make judgments on a paper we can't get?
Well, that's right. We have every legal right to do this, whether we pass this and put this in regulation or not.
Let's put this in regulation, then maybe that'll solve the problem.
Yes. It gives us something to point to in black and white that goes, you know,
Where is it?
you remember which page it's on, Jonathan?
It's the very first page after you turn past the agenda for the committee. It's right at the bottom, page 10.3 under 2635.
I was on the phone the other day with the CEO of a clinic who was contesting, said that they didn't have an obligation to respond to a board issue. Yeah. Investigatory subpoena. So it's just a matter of educating them. And once I explained it to her, she said, okay.
That seems pretty straightforward right there.
We cooked it down to the most basic language we could.
Prior to production of medical records when requested. I remember one time an investigator went to an office in North Mississippi. He said he couldn't give them the medical records because they were on a computer. he called a judge, and the judge said, well, take the computer.
No, I'll never forget that.
That shut the conversation down.
Dr. Kennard is still recovering.
A lot of counseling.
Simple, just take the computer. Yeah. Any questions about this statement on this second page about production of medical? I think that again is a clarification of what we all understood was the process to get, right? Where do the lawyers stand? I get the idea that they don't have to produce medical records for a licensing board. I mean,
They
Harvard,
most of them rely on HIPAA, the strong HIPAA language and peer review language in our statute. They don't realize that the medical board is what we call a health oversight agency that's
Right.
granted an exception under HIPAA and has access to medical records without the patient's consent. And so they're not aware of this.
Well, would it be helpful, just out of curiosity, would it be helpful to maybe include that information in like the newsletter or something that goes out to people to kind of help them
Yeah.
understand that? That seems like
So
that would be,
I think what we do is get it through the OLRC first, and then we put it in the newsletter.
because I think that would be something
And
that
I'm
might
gonna-
might actually be
I'm
helpful.
putting together a whole new traveling speech to start giving people, that's gonna include all the updates to the regulations that we do, so that people are fully informed. So,
But I agree, Michelle, you ought to take his notes from this speech and have a newsletter filler every time.
yeah,
I mean, it's like, here's the updates, what are the rule changes, here they are.
Yeah.
It'd be great.
But, and if it's something that people are struggling with or not really clear about the reasons why, then, you know, I think putting it out there in a way that kind of is facing the licensee's perspective and incorporating that into, so this is why this works, or this is why you can do this and not be concerned about all these other things. I think that part's the important thing, not just this is a regulation, but the kind of some of the background information behind why this is different from what they might believe you do.
I think the lawyers already understand this, but it's their job to obstruct as long as they can.
Yeah.
That's exactly it, Dr. Miles. It's typically not the license.
They understand it,
They're being told.
but if we have it down in black and white where the lawyer can't ignore it, should ignore it.
If controlled drugs are involved and the lawyer continues to say, don't provide it, they go get a search warrant under the Uniform Controlled Substance Act. And then when you present that search warrant to them, they say, sorry, we're not gonna give it to you. You said, you don't have a choice. You go there and you get
Take
the
the
record.
computer, yeah.
Yeah.
That's-
I like your method.
Yeah.
I'm just saying you won't get a lot of complaints. when we
Ah,
try
yeah.
it.
Well, that's David's problem now, not mine. Might have to be heavy-handed, but lawyers sometimes make it difficult.
Yes, they can.
That's their job.
They're just doing it.
That's their job.
All right.
Any other questions on 2635, 2630, 2640, 2615, 2630?
So are we're gonna forget about 2640?
Yeah, we're gonna
Yeah.
take 26.
What was this thing in here about non-telefax and, ERISA?
Okay, so that's in 2640, and I made the decision when we decided to table the rest of 2640 just to include that. But what we're saying there, if y'all want to take a look at that and include it, we can, is that as a physician, you can't give your information to a nurse or an employee of your clinic so that they can e-sign prescriptions for you.
Right.
That's just the same as pre-signing prescriptions and passing them out. Right? Because once they have that password and code, they can go in the computer and prescribe anything they want. And so we're just clarifying, you can't do that. You know, keeping up with technology is going to be a constant challenge for us.
So do we want to change that today?
I think it would be a good idea. I was trying to keep it as least complicated as possible, and I was just going to move that to when we make other changes in 2640,
Okay.
instead of doing one single change in 2640.
Okay, yeah.
But, so, it's intended to be clarification, because right now, you
Yes.
still can't do that.
You can't do it. It's once again, just kind of like you have to let us see your medical records. We're just clarifying it to make it more clear and give us something we can point to and go, this is where it says in black and white. You know, if you didn't already know you can't do that, here's where it actually says you can't do that.
I think most of us already knew you could, we just couldn't show you where
It's
it's.
no different than pre-signing prescriptions and handing them to an employee and go fill them out for the patients as they come through, or your friends or whoever.
There are some licensees that for whatever reason think of e-scripts more like a call-in. And we've been trying to educate them, say, no, it's actually more like a written prescription. In fact, it is a written prescription.
It's your signature
Yeah.
that you're
It's-
electronically handing out when you do that. So,
Because it's your key.
that's right.
Well, a call-in is too, isn't it?
But the way that system works, it's a closed system. And like, say, for example, just controlled substance, it doesn't have to be controlled, but using that as an example, the DEA certifies these two ends of the system as secure to where only the person who's using it is the licensee, the prescriber themselves. And when the pharmacy receives it, they're under the impression that that's who's transmitted that, not someone else who may have had access or not supposed to have access.
And whether you realize this or not, if you have an office employee call in a prescription, the pharmacist writes down who the employee is that called it in.
Yeah.
And so there's a chain there that we can follow. If you're just giving out your electronic signature, we can't follow that. It's just assumed that you did it.
Well, that's no different than giving out your password. That's no different than giving out your password for your EHR.
That's very.
Yeah.
Somebody to be able to go in and chart, yeah.
Question on 2635, chapter 5.
I got a question about 2615. How come we're changing that a physician doesn't have to have an unrestricted license to supervise a PA? Is that is that true for nurse practitioners too?
It will be true for both. I mean, it's written, it's in 2630, 2615 and 2630 are as close to identical as we can make them. 2615 is dealing with PAs, 2630 is dealing with nurse practitioners.
So a physician with a restricted license can supervise a PA?
No.
Why are we striking that first line in 2615?
So we changed some of the definitions around, and I'm not on the page that you're on. And if we were changing the definition, if it's in 1.2, it's a definition.
It's 1.7. It's
Okay.
Oh, yeah, Dr. Lippincott, I can address that. It's addressed in the definition section.
it's addressed.
Under supervising physician.
Okay, so it's just.
That may be you.
How does our feedback?
It's just, okay. So we're not changing the rule, we're just clearing up a redundancy. Thanks.
Something up here.
Is it?
Maybe that computer's sitting on my.
Is that the too much feedback alarm?
Yeah.
Is that on?
No.
Whatever that was. that was it.
Just found it.
Right. It's in the very back. It's literally from board meeting, if you go back 3 pages.
Okay, all right. I'm gonna pay for this.
Oh, yeah.
And so if you keep going back to 1.2, you'll see where we changed the definition. That becomes unnecessary to repeat it right now.
Any further questions?
I have a question. So we're doing, under telemedicine, we're adding in who holds an unrestricted license as well. Under the definition section to practice telemedicine.
I can't hear you.
Under the practice of telemedicine, part 263505.1, under the definition of physician,
Yeah.
means a person who holds an unrestricted license.
Right. So if you want to practice telemedicine in the state of Mississippi, you need an unrestricted license. That's what that says.
Would that be something, I'm just curious, would that be something that should be done during the consent order process, not a blanket? I just don't know, I mean, 'cause it seems like,
No, there's a lot of different, I mean, this is a good example of, we don't allow people to collaborate or supervise mid-levels if they don't have an unrestricted license. So if they have any restrictions on their license, they're not allowed to do those things. We're adding telemedicine to that list of things they're not allowed to do if they have restrictions on their license.
my only concern is just the nature of the way the session went, the telemedicine, and they're viewing it as the same level as practice medicine. So it just seems a little out of balance with that.
I don't understand what you're asking. To practice telemedicine is practice medicine. Level field.
Well, that's not completely true. Because practicing medicine physically here in the state of Mississippi, my investigators can show up at your office. They can show up at your home, they can show up wherever they need to. If you're doing telemedicine in California, and we can't just show up and ask for records and regulate you the same way as we can regulate an in-state physician. So we're making it a little bit higher bar to climb. If you've been disciplined in another state, if you have restrictions on your license, then you can't practice telemedicine because it makes it more difficult for us to regulate.
So is the unrestricted license any unrestricted license or only unrestricted? I mean, they have to have a Mississippi license.
They have to have an unrestricted Mississippi license to practice telemedicine within the state of Mississippi.
So like currently, if I'm a family physician working here in Jackson, I can currently do telemedicine under the COVID and get reimbursed, through insurance. So that's one thing they're looking at changing legislatively is to continue that post-COVID. So if I get a restriction on my license, that really has nothing to do with if I can still practice medicine here, then now you're saying I can practice medicine in my office, but I can't do my telemedicine.
And you can't collaborate with mid-levels or supervise PAs. So there's a lot of things that happen when you get a restriction on your license. So that's kind of the whole purpose of having a restricted license, is it restricts the things you're allowed to do.
It'll also cause uproars in insurance. You'll lose your slot on the insurance with a restriction.
Well, I mean, that's true of me, like, but I'm just saying like that person's not gonna be able to do. the telemedicine.
Yes,
Apparently, I'm the only one that's looking at the agenda. We're now about 7 or 8 minutes from being 1 hour over. If we need to bring this to conclusion.
okay. We're also 20 minutes from the start of the next week. Any other questions about 2600?
I can't hear you.
No, I just, So we're in rules and regs
Yeah,
right now.
Uh-huh.
And before this, we had an executive committee, our agenda was a little different. We started at 8:30 with nominations. And then we started, well, technically at 9 o'clock was supposed to be the beginning of the rules and regs. So we're not that bad. Our board meeting doesn't start with 10. It's different from most days. So we're, no worries. We appreciate
This
it. Thank
has
you for
drug out a
keeping us
little
on
longer than I
time.
thought it would, but we had some questions that we didn't foresee. So now I'll ask you, anybody else have any questions about 26, 35, 26, 15, anything? Most of this is semantic changes, a few minor changes for the lawyers, if they need help. If there's no other questions. Being adjourned.
We don't have to vote.
Don't you want to pass it out of committee before you adjourn the meeting?
Okay, we can do that too.
Move to unadjourn.
So we'll pass this out of committee to the full board. Yes, right.
So that'll be the recommendation for
A motion.
today.
A motion, second, third.
So is the board gonna vote on all these changes?
As soon as we send it to them, all in favor, send it to the board. Okay. So this will be presented to the board. I think the whole board's here, except Dr. Gillett.
Dude.
I mean, it's still, I mean, everybody here is not on rules and regs. So there are people in here that are not on rules.
Right.
But I mean, if, for discussion purposes, maybe it won't take as long.
Yeah, I'm gonna wait to present the nomination.
At the regular board.
Yeah.
So next on the agenda is the regular board meeting. with 10.
Correct.
Y'all already done nominating, right?
Yeah.
Okay, all right. Yeah, well, I was gonna ask you, what, I mean,
Yeah.
okay. Okay.
Maybe we should, Casey swears me in, and then I like to check.